Please bow with me for a moment of silent prayer.
Thank you. Everybody have a seat. Okay, bring them around. Hello, thank y'all for coming on short notice. You raise your right hand. You solemnly swear or affirm that you will conduct your duties as members of the grand jury of Monroe Circuit Court and keep all matters confidential that you hear therein, be fair and just, to protect and defend the Constitution of the Commonwealth of Kentucky, United States of America. Do that? Sure.
David, can I say one thing?
No.
You've done a wonderful job with Pam Miller's funeral.
Turn that off a second. I didn't hear you.
I said, I just wanted to tell you, your words was very heartful at Pam Miller's funeral. I was the one who stayed with her for 2
It
years.
was easy to talk about her because she was, Johnny's having a hard time.
He really is. I just now talked to him.
I called him a couple of times.
I had stayed with her for the last 2 years.
She was courageous, wasn't she?
She was just hard to fight. Just, but I wanted to tell you that your words was to the car.
Thank you. Okay, let's go back on the record. Let's do transported prisoners. Commonwealth versus Brian Elliott for sentencing. Come on around here. Are you Brian Elliott?
Yeah.
Good morning. We're here today for sentencing in 19 CR 00123. Mr. Elliott, were you born in 1976?
Yeah.
Last four digits, social security number 1403.
Correct.
Okay, have you had an opportunity to look at the pre-sentence investigation report done by probation or parole? You reviewed the pre-sentence investigation report done by probation and parole. Have you seen it?
We did at the jail the other day, Your Honor.
Now, he needs to tell me that he did it. Did you review it? Is it substantially correct?
Yeah.
Okay. Is there any reason why he should not be sentenced?
No, Your Honor.
Pretrial diversion was voided on January the 15th, 2026. He's therefore sentenced to 3 years, credit for time served.
Thank you, Your Honor.
Thank you. Jacqueline Fancher. Are you Jacqueline Fancher?
Yes, sir.
Good morning.
Good morning.
You're here in 25 CR 0062 to look at a pretrial diversion revocation. Were you born in 1985?
Yes, sir.
What are the last four digits of your social security?
7569.
Okay. What does the Commonwealth have to say about this?
Your Honor, she has a 2-year sentence on possession. She signed an admission sanction form, May 11/25. She was assessed for treatment and never did go.
Your Honor, we've done an agreed order in lieu of revocation, accepting her into drug court.
Yeah, that's true. I would have that order down, agreed to an order for assessment if she wants to go and the court's willing to go. She came in on the rocket docket, never really got started. If she wants to go to drug court, that'd probably be a good plan, but she'd have to set the jail until she's assessed. I would agree with that totally.
In lieu of revocation of
Yeah,
pretrial
I'll give
diversion?
her a break if she wants to get a revocation, but
Okay, have we signed an order?
No, I've received the order.
Okay, I'll sign an order referring her to drug court to see if she's accepted. We'll, as soon as it happens, we'll take a look at it, okay?
And Your Honor, if I may, she has type 1 diabetes, and it's my understanding that the jail is not wanting to purchase a medication because it costs $1,800. I believe her glucose may be in the 500-600 ranges. So she has asked if she could be released, if she is accepted into drug court rather than waiting the month for the next drug court date, if she could be
I can take drug tests.
early released.
I'm not gonna do that. I'm not gonna do that, but I'll immediately look into to see if they're not providing her medication. I don't understand that.
It's my understanding she doesn't have a prescription. It hasn't been refilled, and so the cost is $1,800.
How long has it been since she's been taking it?
I've been taking it for.
No, I mean, I don't want you to, that's a rhetorical question. I don't want you to ask about your medical history on here. You need to look into it. Has she been not taking her medication regularly before she got incarcerated? Where was she getting it then? Look into that and get back with us, okay?
Yes, sir.
Thank you. James Farber. Let me speak to someone from the jail just for a second. Did you hear somebody come up here? This last person, Ms. Jacqueline Fancher, said that she wasn't getting her diabetes medicine. She's a type 1 diabetic. She's made that complaint on the record here, so y'all need to have somebody look into that immediately.
Have to get her talk to them.
You have immediately call over there and see if they're doing that, because if they're denying her medication, she could have some.
Okay.
Okay, thank you. Are you James Farber? Good morning. You're here on 25 CR 0059 for sentencing. Mr. Farber, were you born in 1994? Last four digits, social security number 0603. Have you had an opportunity to pre-sentence investigation report done by probation and parole? Is it substantially correct? Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty to operating motor vehicle under the influence, the defendant shall serve 7 days in jail. Second offense, and pay a $300 fine plus court costs. On plea of guilty to possession of controlled substance, first degree self-defense, defendant shall receive a sentence of 2 years. Plea of guilty with tampering with physical evidence, he shall receive a sentence of 4 years. The 2-year sentence, the 4-year sentence shall run consecutively, term of 6 years. Probated for 5 years, defendant shall enter complete long-term rehab. Scheduled through DPA. He shall remain incarcerated to the morning of the bed date. And next be transported by probation and parole. And he shall meet the obligations of testimony. Okay. What are the total court costs in this? Okay, I'll allow you to start paying that at $50 a month, 30 days after your release. Okay? And it's and you got all the paperwork on the DUI paperwork, correct?
Your Honor, I have his signed DUI form here, if I could turn it into the court.
Okay,
May I approach?
give it to the clerk there. You do realize that the DUI is enhanceable. If you get another DUI, you already had them before. This is your second one. The third one will be enhanceable. You understand that? Okay, thank you very much. Gary Hall. Okay, Tiffany Hitson.
Okay, so where we go? What's our violation?
Come on over here, please. Commonwealth of Kentucky versus Tiffany Hitson, 22 CR 0026. Are you Tiffany Hitson?
Yes, sir.
Come on up here, Tiffany. Good morning.
Good morning.
You're here on 22 CR 0026. Ms. Hitson, were you born in 1994?
Yes, sir.
Last four digits, social security number 5920.
Yes, sir.
We're here on a pre-trial conference. What do you have?
Your Honor, this is actually a probation revocation. Myself and Mr. Stockton submitted an agreed order in lieu of revocation earlier this week for Ms. Hitson to enter into a long-term treatment program at True North Treatment Center. I have a copy of that agreed order and bed letter here for the court.
Your Honor, this was the lady, she's got 5 years on receiving stolen property. My understanding is this treatment is a dual diagnosis treatment center, where she has been before, and she's supposed to have a higher level of care. There is some mental health issues going on, and so the reason I agreed is you have found it back in August 24th of 25.
What are you gonna do with her?
Want to go to North Care. My understanding is the dual diagnosis center, and she's supposed to have an increased level of care. Is that right, Ms. Hill?
Yes,
For how long?
the program is from 6 to 8 months, Your Honor, and the last portion of the program is considered to be transitional living, which will assist her with getting a job and being able to maintain sobriety within the community.
Well, I want to include it in the agreed order that if she leaves the facility, she should report immediately to the Barron County Jail.
I can.
Yeah. Okay. Michael Ludwig. Are you Michael Ludwig?
Yes, Your Honor.
Good morning.
Good morning.
You're on 25 CR 0067 for a pretrial conference. Mr. Ludwig, were you born in 1976?
Sir.
Last four digits, social security number 1016.
Yes, sir.
Okay, what do we have here, Commonwealth?
Have a felony plea, Your Honor.
I've just been informed that the motion's been filed that says you wish to enter a guilty plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 0067?
Yes, sir.
Is your judgment impaired today in any way?
Yes. Oh,
Is your judgment impaired? Do you know what's going on here today?
yes.
It's not there. Is your have you discussed this matter with your attorney and you're satisfied with her advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I accept the plea, I'm going to go over those rights with you. You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. Right to be represented counsel to jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. The process issue to compel their attendance. Right to appeal this matter to a higher court if you lose. And the right to require the Commonwealth to prove on a reasonable doubt that you, beyond reasonable doubt, you're guilty of charge. You understand that by entering a guilty plea, they give up those rights. You understand that?
Yes, sir.
And we consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait for a pre-sentence investigation report to be done by probation. Parole. I do not accept the Commonwealth recommendation after reviewing that report and decide to impose a harsher sentence. You have a right to withdraw your plea. You understand that? Mr. Stockton, will you come around and tell us what the recommendation is?
Yeah, Mr. Ludwig will plead guilty of failure to register as a sex offender first degree. He'll receive a sentence of 2 years, probated for 2 years. He'll get credit for time served, release at final sentence, and pay court costs at discretion of the court.
Okay, now,
The file here.
you know, why are we probating Mr. Ludwig a recommendation?
Well, the only thing I can tell as far as his history on this is he hadn't had anything in many years, and that's the reason for the probation.
Yeah, but we'll take a look at it.
Yes.
Pre-sentence investigation for. Is that your understanding of the recommendation?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Are you doing so your own free will?
Sir.
Knowing your constitutional rights, explain to us it's still your desire to give up those rights and allow the court to fix your punishment. Is that right?
Yes.
Okay, you understand that by entering a plea that by entering a plea today, any future convictions could be enhanced as far as under persistent penalty offender law. You understand? Is that your signature on the motion offered?
Yes, Your Honor.
Okay, well, I'll accept the, plea. Schedule your sentencing for March the 19th. Okay?
Yeah, thank you.
Courtney Mabry. Commonwealth versus Courtney Mabry. Is it Mabry or Mabry?
Mabry, sir.
Mabry, okay. Good morning. You're here on 23 CR 0020 for probation revocation. Miss Mabry, were you born in 1993?
Yes, sir.
Last four digits, social security number 9966.
Yes, sir.
What does the Commonwealth have to say?
Miss Mabry has a 3-year sentence on possession of controlled substance, first degree. I think she began supervision sometime in 22. She was transferred, they was going to transfer to Tennessee and was having trouble transferring her. So she was placed on unsupervised probation. She went and completed a year-long treatment in Tennessee. The provisions of her probation was she was not to be back up here. After she completed that, then she was arrested for DUI here in Monroe County, tested positive for marijuana, benzos, and meth, and admitted to IV use. So we're asking for revocation. I've got Mr. Collins in the state.
We're stipulating.
No, sir. We look to that here.
I have one there.
Mr. Collins first, and then I'll get you with me.
Raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Come up toward the microphone. State your name, who you're employed with.
Chase Collins, I'm employed with the Department of Corrections, Probation and Parole.
Okay.
Mr. Collins, can you give the court some background as to what happened on Ms. Mabry's case? Why she was placed on unsupervised probation?
Yeah, she was granted probation in Monroe County. And on a 6/24/24, she was placed on unsupervised probation due to transfer problems from Kentucky to Tennessee. And we were going to leave her on unsupervised as long as she resided outside of Kentucky. She entered and completed the Emmanuel House in Tennessee. It was a year-long program. She actually completed that program in May of 25, and she remained on unsupervised the entirety of that. So,
Okay. Now, did you inform her if she came back to Kentucky, was she to report to you?
she knew that, yes. I believe that was stated in court when we were there that
You
day.
personally
Yeah.
informed her
Yeah.
of that? Okay. Now, when was the next you had then with Miss Mabry?
Next contact I had was on 1/6 of 20 a DUI in Monroe County case number 26T15. Went and seen her at the jail. And at that time, she admitted to the use of marijuana on or about 3 or 4 weeks prior to 1/6/26. She admitted to the use of Xanax on or about 2 or 3 days prior to 1/6 of 26. And on 1/6/26, she also admitted to using methamphetamine on or about 2 days prior to 1/6/26. And she did admit that she was currently using by way of IV use.
Okay. I have nothing more, Mr. Collins.
Any questions?
Just a couple here. Officer Collins, it was your understanding she was still residing in Tennessee.
Supposed to be, yes.
She had just been pulled over, I believe, on a highway by a state trooper.
Yes, I believe if I remember correctly, she was maybe seeing her kids. She was up here to see her kids, I believe is what she stated.
And other than the DUI, you're not aware of any charges during the time of unsupervised or supervised?
Not aware of any of those, no.
No further questions, Your Honor.
Are your next witness?
Call Trooper David Mabry.
You're all right.
Raise your right hand, please. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
I do.
Please state your name with whom you're associated and employed by.
I'm Trooper Daniel Mann, Unit 582 out of Post 15, Columbia, Kentucky State Police.
You may proceed.
Trooper Man, did you have an occasion to see Miss Major on January 5th, 2026?
I did.
And tell the court what happened.
On January 5th of 2026, at approximately 3:47 hours, I was traveling Kentucky 100 in a community of Gamale when I observed a silver passenger car traveling at a slow rate of speed. It was roughly around 37 miles an hour in a 55-mile-an-hour zone. I performed a traffic stop at this time, and I made contact with Miss Mayberry. As contact was being made, there was a large amount of marijuana odors emitting from the vehicle. As I smelled the marijuana, I asked the operator, Miss Mayberry, if she had smoked any or if there was any in the motor vehicle. She disclosed no, but it was legal in Tennessee. As these statements were being given, Miss Mayberry's actions were very nervous and sped up, constantly telling me she felt like I was out to get her. With evidence from this conversation and observation, it was believed that Mayberry was under influence of some type of illegal drug. Standard field sobriety and ARI was performed following this, where the instructions were clearly given. But during these instructions, Miss Mayberry failed to take clear instructions. Even though given multiple times, she tried to begin the test before, also counting out loud during other portions of the test. As the test was being performed, she was told numerous times to follow my finger, not turning her head and just following the finger at all. And she would also turn her head and also not follow my finger, which I had to repeat to her numerous occasions. During the test, there was numerous clues that showed impairment. Miss Mayberry was placed under arrest where she was read her Miranda warnings and disclosed she would still speak. Later on, she ended up disclosing that she ended up relapsing and began the use of illegal drugs again.
Did she state what kind of drugs she was using?
It was a methamphetamines. Yes, correct.
Now, what kind of training and experience have you had as regard to driving, operating vehicles and things?
I've been through standard field sobriety and ARI training.
Okay,
I have 7 years in as a trooper.
okay. Based on your training and experience, was she operating that vehicle under influence that day? You should stop.
That's correct.
Have no more questions.
Would you like to inquire the trooper?
Just a couple here. Trooper Man, she was alone in the vehicle.
That's correct.
Correct. And she did consent to a blood test?
She did.
Okay. No further questions, Your Honor.
This officer be excused.
May, Your Honor.
Thank you for your attendance. You may be excused.
Thank you, Your Honor.
Thank you. Hey, would you like to be heard?
Your Honor, at this time, I would like to ask for Ms. Mabry not to be revoked. We've heard testimony from Officer Collins. She was placed on unsupervised probation. She successfully completed a year-long treatment program. It appears that this is a relapse, Your Honor, and so we would be asking for the ability for the court to send her to treatment in lieu of revocation. She was alone in the vehicle. There's no indication that she was residing in Kentucky. She was traveling through. And so at this time, we would ask for her to enter a long-term treatment. If you do end up revoking her and you are open to shock, it will take longer to get her into treatment since she does have Tennessee insurance. And so this is going to be the quickest way to get her into treatment to help her with her IV use, Your Honor, and to help get a handle on that. She has been able to show that she has successfully completed treatment, and I believe that she'll be able to successfully complete it again, Your Honor.
I'd ask that she be revoked. She's used illicit drugs. She's came up here without reporting to Mr. Collins. And yeah, she successfully showed she can complete treatment and still be a danger to society. Still, I'm thankful nobody was hurt or injured while she was up here operating this vehicle under the influence. So I'd ask she be revoked.
Well, you know, you didn't stipulate to the facts, but you didn't deny any of the facts either. I mean, that obviously she was arrested for driving under the influence. It's my situation. She was already given a big break by allowing her to go down to Tennessee and go to that treatment situation. And she comes up here, it's on the public highway in an intoxicated situation. If a school bus had been coming down through, the children killed in it, wouldn't have cared whether she had a temporary relapse. So a couple of things that really get me more than anything else is weapons and driving under the influence. So I'm going to revoke her. I hope she turns it around. I'm glad you didn't hurt anybody. Kenneth McLeod.
Your Honor, may I?
Kenneth McLeod.
There you go.
Are you Kenneth McLeod?
Yes, sir.
Good morning.
Good morning.
You're on 25 CR 0066. Mr. McLeod, were you born in 1991?
Yes, sir.
Last four digits, social security number 7904.
No, it's 01. Yeah.
01. Okay, we have a misprint here. Please take note on the record. We're here for pretrial conference. What are we here for?
We have a felony plea, Your Honor.
We've just been informed that a motion has been filed, sir, that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely, voluntarily given?
Yes, sir.
Are you the person that we just previously identified in 25 CR 00666? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go over them, and at the end, I'm going to ask you to understand if anytime you have any questions, step away from the podium and ask your attorney. You have the right not to testify against yourself. No one can make you say anything. You have the right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation report from probation and parole. After reviewing that, if I decide not to accept the Commonwealth's recommendation, if I decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Mr. Stockton, what is the Commonwealth's recommendation? Will it come around?
Your Honor, Mr. McLeod would plead guilty to failure to comply with sex offender registry second offense, receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall receive credit for time served, and all evidence in this case would be destroyed, and he wouldn't be released to final sentence and pay court costs at discretion of the court. A little background on this, he was about 22 or 23 years old when he was convicted of statutory rape in Putnam County, Tennessee. And I can't find any violations of the law except for these failure to register.
Is that your understanding of Commonwealth's recommendation?
Yes, sir.
Okay, are you pleading guilty because you did commit the acts charged in the
Yes, sir.
indictment? You serve your own free will.
Yes, sir.
And on your constitutional rights to explain to us still your desire to proceed and allow the court to fix your punishment in the range permitted by law.
Sir.
You understand that after entering a plea of guilty, any future convictions could be enhanced as far as the range of penalty. You understand? That's your signature on them?
Yes, sir.
Now, accept the agreement or pre-sentence investigation report, have set your sentencing for March the 19th. Is there any reason to take him into custody evidently?
I thought it was in custody. but
He
he's not.
came from the crowd, didn't he? Did you come?
Oh, okay. I was confused because it said transported. I thought it was in custody. So I'm fine with the ankle monitor. Yeah.
Okay,
You must have made mine.
stay out of trouble. You'll be here on March 19th.
I was trying to look for a job too.
Okay. Nathaniel Metter.
Shaking when I said he started on that. I could tell he got nervous.
Nathaniel Metter. Are you Nathaniel Metter?
Yeah, speak up.
Sir.
Good morning. This is 22 CR 0017. Mr. Metter, were you born in 1997? Last four digits, social security number 2309. This is a motion for supervised probation.
Your Honor, Mr. Metter was in the specialty court and he was discharged because it says on the report, due to mental health evaluation by life skills, defendant is not appropriate for drug court participation this time due to his current mental health. So I'm moving for supervised probation, and I think it would be wise for a mental health assessment to be done and any recommendations be followed if that Mr. Metter's having difficulties.
Objection.
You get that?
Okay, well, I will, sign an order, put him on supervised probation. And one of the requirements that he submit, can you arrange a mental health evaluation one?
Your Honor, what we have is, I'll instruct him to go over the life skills, have his mental health assessment there, and then they'll be able to.
Can you do that? Okay, well, you need to report back probation and parole. When can he be released? When can you meet with him?
I can meet with him. If he can come to Glasgow Monday, it'd be great.
I'm not sure.
Get released.
Is it drug court holding?
It's not us.
That's what I
Yeah,
thought.
I keep the release.
Who's holding him?
Ordinance Deputy Richardson, he said drug court is, and I don't know the reason.
Court had shown a drug court violation warrant served in November, so I'm not really sure.
They've relinquished their jurisdiction over it, so I guess you can decide what you want to do.
Well, let's look into why he's being held. I mean, if,
This says that he's not in the program anymore.
Yeah, that's right.
Administrative.
Well, could we have
would
him
that
say,
show any other reason that he's incarcerated?
No, that was the only warrant. That's the most recent warrant that's been issued.
Well, I'm gonna have, what time on Monday can he be there? Can you receive him probation, parole? Mister,
Yes, sir.
what time Monday can you receive?
9 a.m. would be great.
Okay, I'm gonna release it.
I've got some concerns. I've spoken with his mother in this case, and I don't know if Mr. Metter will get there.
Well, I'm not gonna let him out until 8 a.m. on
Okay,
Monday morning.
I'm just informing the court that he may
Would you
not
think that'd
make
be
it.
appropriate?
I don't know if we shouldn't have the assessment done and maybe review this, because I don't know that he would voluntarily go or participate. Yeah, I know he's made statements to her and Mr. Collins that aren't rational, I think. Is that?
Your Honor, I think we had him on probation before we put him in drug court, had some issues, and that's why we sent him to drug court.
I'm not trying to punish Mr. Metter. I just want to get him some help before he does anything, gets
But-
himself more in trouble.
Suggest what I do then. Give me a suggestion.
I would just hold him and let him be lined up for the treatment and get back with us and maybe review this in 30 days. And I'm all for releasing him once he's set up for
I
the
mean,
mental health he needs.
Don't have enough information to decide whether to release him or not. Nobody,
Yeah.
until you just told me,
Well, that's the issue. Yeah, and according to Deputy Richard, part of the problem with drug court is he just wouldn't participate and come to these required meetings.
I don't know why they're not trying to revoke him then, instead of giving him supervised probation if he wouldn't participate. I don't know, it's unusual.
You know?
I agree to, going to life skills like how I asked.
Yeah, I guess so. Well, I'm just gonna take this under advisement. And y'all take a look at it a little closer. You go over and interview him over there and see what kind of services are available. And if we need to have an evaluation done on him before I make a decision on whether we have him on probation or not, then we can do an agreed order, okay?
We can have our social service clinician meet with him at the jail and see if maybe there's a dual diagnosis facility maybe he could go to get some help with that. I can have her.
I just need a little bit more to see what Mr. Metter needs, okay? Take it under advisement and wait for y'all to work it out. Silas Tabor. Okay, you take care of yourself, man, okay?
Your Honor, I don't believe Mr. Tabor's here. It's happened to me for the second time. We were at the negotiation earlier. We've got a counter. I need to communicate that with Mr. Tabor. I wanted to do so. Is he? Oh, jumped it. Sorry about that.
Commonwealth versus Silas Tabor, 25 CR 0042. Are you Silas Tabor?
Yes.
Good morning.
And Judge, I
Let me get him in front of me here, okay? Just hold your hostage here. This is 25 CR 0042. Mr. Tabor, were you born in 1976?
Yes.
Last four digits, social security number 6042. Now you want to consult with him about an offer that's been made?
If I could, Your Honor.
Okay, well, provide them a place to meet back there, okay? Okay. Kristen Williams.
Morning, Your Honor. Lee Davis for Ms. Williams.
Commonwealth versus Kristen Williams, 25 CR 0046. Are you Kristen Williams?
Yes, sir.
Good morning.
Good morning.
Were you born in 1989?
Yes, sir.
Last four digits, social security number 7658.
Yes, sir.
We're here for a pretrial conference. What do you have to say?
We've reached an agreement, Your Honor.
Is it a felony plea?
It is, sir.
Okay. A motion has been tendered that says you wish to enter a felony plea. Is that correct?
Yes, sir.
Are you currently on the influence of drugs or alcohol?
No, sir.
This is plea freely and voluntarily given.
Yes, sir.
Are you the same person that we just identified in 25 CR 0046?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Is your judgment impaired today?
No, sir.
Okay. Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to go over those rights, and I'll ask you when we conclude if you understand them, okay?
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, excuse me. You have a right to a speedy trial by jury, to be represented by counsel at your jury trial, to confront and cross-examine all witnesses, call to testify against you, produce evidence, call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court. If you lose, the right to acquire the Commonwealth prove beyond a reasonable doubt that you're guilty of charge. You understand that by entering guilty plea today, you give up those rights. You
Yes, sir.
understand? And I may consider the Commonwealth's recommendation, but I may apply any range of sentences by the law. I don't have to accept it. Prior to accepting your recommendation, I'll have a pre-sentence investigation report done by Probation Pro. After reviewing that, if I decide not to accept the recommendation, impose a harsher sentence, you have a right to withdraw your plea and go to trial. Do you understand that?
Yes, sir.
Mr. Stockton, what is the Commonwealth's recommendation?
Ms. Williams will plead guilty to trafficking in a controlled substance, first degree, first offense, receive a sentence of 5 years, serve 180 days in jail with the balance probated for 5 years supervised. She will enter and complete an in-house rehab determined, scheduled by defense counsel and agreed upon by the Commonwealth. After the 180 days and on the morning of the bed date, she'll be released. Probation Pro shall transport the defendant's facility. She will receive credit for time served. Once she's released from the rehab, she'll obtain and maintain gainful employment or do 30 hours community service a week and pay court costs at discretion of the court.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
You're doing so your own free will.
Yes, sir.
Knowing your constitutional rights to explain to you it's still your desire to give up those rights, enter a plea and allow the court to fix your punishment.
Yes, sir.
You understand after entering this guilty plea, any future conviction to felonies could be enhanced under persistent felony offender law.
Yes, sir.
Is that your signature on the document?
Yes, sir.
I accept the agreement order pre-sentence investigation report scheduled for hearing on March the 19th.
Your Honor, I do have a jury trial that is scheduled for the 19th. I don't know if that's going to go, so.
Well, what we can do is just leave it there. You can contact us and maybe we'll get somebody, you go over the information with her and maybe we'll get somebody to stand in for you that day or something.
Yes, sir,
Okay.
please. And Your Honor, I'd like to say one other thing on the record, that the Commonwealth does agree not to oppose expungement after the requisite time if she completes it with no violations or no other problems.
Well, I told Mr. Davis that, as Coach Claiborne used to say, it's hard to play the old iffing game, but if she completes probation, and if I'm around 5 years and the law is in accordance, I'll agree to it.
Okay.
Thank you, Your Honor. May I be excused, sir?
Absolutely.
Thank you.
You know, we had probation pro officer wants to meet with. We had Gary Hall. Go ahead.
Oh.
We had Gary Hall earlier.
He downstairs.
Are they ready on Silas Tabor? Okay. Gary Hall.
I didn't think that, yeah, I like that.
Commonwealth versus Gary Hall. 25 CR 0069. Are you Gary Hall? Good morning. Were you born in 1978?
Yes, Your Honor.
Last four digits, social security number 6975. You're here for sentencing today. Have you had an opportunity to review? Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
Upon plea of guilty possession of controlled substance, first degree, third offense, methamphetamine, he should receive a sentence of 3 years, probated for 5 years. He shall enter and complete the specialty court, which you are participating in. And this 3 years shall run consecutively to the time set out in 23 CR 0044. What's the court cost involved in this?
$240.
Need some time to pay that?
Yes, Your Honor.
Okay, well, as you pay $30 a month, first payment due 30 days after you end your incarceration. Is he gonna be probated now or?
Well, he'll be released when, I guess, if he's ready to enter drug court. Have you been oriented?
I've been
He was
downstairs.
down there. He's already in swag.
They'll do the release.
Yeah, they'll do the orientation.
Okay,
I'm agreeing whenever they're ready to orient.
okay.
Thank you, Your Honor.
Yeah.
Thanks, sir.
Got Silas Tabor's on the other one.
Yeah, his attorney talked them out.
Yeah, here he is now. You'll bring Silas Tabor on back on there. Silas Tabor. You've been previously identified, Mr. Tabor, and you presented the counteroffer to Commonwealth. Was it accepted by Mr. Tabor?
It was not, Your Honor. He's asked me.
Schedule a trial date.
Your Honor, he has asked me an opportunity to confer with other family members and think about it. If Your Honor would not allow that, then we can schedule a trial date today.
I've got a victim in this case, Your Honor. The one reason I agreed to the amended plea was so that she wouldn't have to go through 2 trials. Allegedly, she was abused by Mr. Tabor and Mr. Tabor's brother. And if he wants a trial and they want to put her through 2 trials, she'll just have to go through 2 trials. But that's the reason I agreed to this amendment.
What was the offer?
I think it was it 5 or?
Judge, he's offered to get rid of the sexual abuse charge and be an assault charge, 5 years to serve, consecutive to a 5-year sentence he has out of Adair County.
And the reason I did agree to do that, we conferred with the victim and that was going to save her 1 trial.
You withdrawing that plea though?
Yeah, if he doesn't want to accept it.
So you'll be tried now on the sex thing and the assault.
Correct. He wants a trial.
Okay, when we're fixing to give him a trial, what, get your calendar, Rich?
I do, Your Honor.
Now, do you have any witnesses you need to get?
She's got to say, I have to domesticate some subpoenas, yes. And I would prefer to do it after, O'Donnell. We've got 3 trials between March 11th and we've got a special prosecution April the 1st. It'll probably take 2 days in Wayne County.
And that's fine, Your Honor. I'm completely open at mid-April and on would be open for any trial dates the court had at that point.
You got the new trial in June 22nd.
That's correct. I don't care to put this one before that if you want
Yeah.
to.
How about May the 10th?
I think that'll be a little too close to O'Donnell. I'm thinking it'll take 2 or 3 weeks.
Not,
May the 10th on a Sunday.
you want,
May the 10th.
I'm like you, Judge. I hope it doesn't.
I know it's not good.
Okay, well, you got the control.
Yeah.
You know, I'm not opposed to speedy trials.
What is it?
May the 10th is on a Sunday.
But the problem is getting prepared for this. We'll need a few days to get prepared for it.
I was looking at the 13th, it's at 17th. How about May the 20th?
That's fine with the Commonwealth.
Defense is available that date, Your Honor.
Okay.
Any other witnesses we got in Indiana?
One day.
Yeah, one day.
Great. See you then.
Thank you, Judge. Be in touch.
Commonwealth versus Justin Adams. Y'all don't have anybody else you got back there transported?
We got one cousin, Greg Brown. Greg Brown, both. Sure. Bruce Brown.
Is he on the Barron County active warrant? Okay.
Well. I'll read, when you're the Saturday.
Sound good.
The judge and the other sentencing, got to maybe on it. No, just do the one where the third king can address that for judge. Yeah.
Are you Justin Adams?
Hi.
Good morning. You're here for the purpose of arraignment in 26 CR 0006. You have an attorney?
Yes, he said. I believe it's gonna be requested with PA, Your Honor.
Did you have public advocate in the district court?
Yes.
I'll continue your appointment. Were you born in 1999?
Yes, sir.
Last 4 digits, social security number 0522.
Yes, sir.
Here for purpose of arraignment, your right to remain silent. The grand jury of Monroe County has returned an indictment charging you possession of controlled substance of first degree methamphetamine and possession of drug paraphernalia. You understand what the charges are?
Yes, sir.
Counsel, you acknowledge the identity of your client received indictment, waive formal reading and arraignment, interplead not guilty, reserving all pretrial motions.
Yes, Your Honor, we do.
Sign a reciprocal discovery order. Requires the Commonwealth to provide you with information to prepare for your defense. You'll be here on March 19th for your next court date. What is the negotiation date?
Well, I had it written down. What is it?
I think it's the 6th,
It's the Friday, first Friday in March, 9 a.m., March 6th.
3-6.
March 6th at 9 a.m. and March 19th at 9 a.m. Both of those are conditions of your bond, okay? Nicholas Burge. Nicholas Burge. Commonwealth versus Nicholas Burge, 25 CR 0071. Are you Nicholas Burge? Good morning. Were you born in 1985? Last 4 digits of your social security number 3658.
Yes, sir.
You're here for a pretrial conference. What does the Commonwealth have to say?
My understanding was Mr. Bell wanted another month. I'm gonna see 2 months.
Yes, sir.
Well, would you care to share with me why we want too much or?
There's some, the case is very convoluted. There's a lot of different facets of it that I need to investigate and look into through
What is the
family.
charge?
Assault, first degree. There's a video of a fight between Mr. Birds and the victim. Second degree. I'm sorry. What?
It's assault second and video.
There was a lot of witnesses and stuff involved, Judge. I've also got two major trials coming up over the next 2 weeks in a row. One in Hart and one in
What's his
Barron.
bond? What kind of bond is it?
Your Honor, it looks like he had was it 10,000 cash or double his property and with preaching on.
Yeah, Mr. Collins is supervising him out of Metcalfe County, is that correct?
That's right.
Have they filed a motion to revoke over there on some of these new charges?
They did, we had a hearing up there on the initial arrest, and he done 60 days on graduate sanction up there. And it was released, so.
On this charge? Does he have an ankle bracelet on?
Does it? No.
But you putting it out that far. I'm gonna order a conditional bond, bond conditional ankle bracelet and put him under a curfew.
Could we get home incarceration, Judge? I'd rather have home incarceration than a curfew.
Well, you don't have to do it. I know what, you said your client would rather have that. I don't understand what you're saying. I'm letting him have a curfew to be out during the day with an ankle bracelet.
He's good with home incarceration.
Works good.
He could go to work and that'd be it.
That's what I'm offering him. That's what my curfew is.
Judge,
What do you consider home incarceration?
whether he's
We've got
not
a
allowed to do
definition.
anything but go to work and back. He can't go to the grocery store. He can't get out and do anything. He's on home incarceration. And the reason I'm asking for it, Judge, is the jail credit. If you're on home incarceration, you get jail credit. If you're on curfew, you don't get nothing. So if I'm on rodeo, I want to ride bulls. If he's gonna have to have an ankle monitor, I want him to go all in, so he can at least get credit for it. And it would, we're asking,
Put him in jail then.
well, I don't want that.
If we're gonna go all in, I'm willing to go all in.
Well, I misspoke then. I want to rope
Here's the thing
steers.
about it is you want a couple of months here and, without any, it's a complicated case and I'm sure if it's not, it will be by the time you have a couple of months to work on it. But
Judge,
what does the Commonwealth want to do on this?
If he wants to do the ankle monitor, I'm enthused that Mr. Bell thinks there's a possibility we might convict him since he's won ankle monitor, so.
I didn't say that. I mean,
In defense of ankle monitors, he's technically going to be on curfew. It's the only thing he can do is go to work and come back home at the state.
which is home incarceration. I just wanted to,
That's what I call a curfew. And so that's what I'm gonna offer him, a curfew, or he can go to jail, either one he wants to. He's lucky to be out anyway. He's got a first degree assault and a PFO,
Second assault.
second degree assault, which could be taken up on a PFO, right?
and Judge, there's some very strong mitigating circumstances concerning.
I'm
this,
sure there
too.
is, or he would have pled guilty. I'm not saying he's guilty. I'm
Right.
just saying that I'm concerned about anybody with these charges. And he goes to another county and they give him like 60 days or something like that. I don't know. So he's on a curfew with an ankle monitor. Okay, thank you.
Thank you, Judge.
And I guess it's set for April then? Whatever day.
April the 16th. What's the negotiation day in April, you know?
I do, it'd be,
Can't read it, it's too close.
I was gonna schedule April the 3rd. But according to the clerk, the Justice Center's closed on Good Friday. So,
As it should be.
yeah, at least half a day.
Don't want to offend anybody, but observing Christian holidays for sure, so.
April motion, negotiation on April 10th. Be the next Friday. Is that okay?
It's
Be April the 10th.
April the 10th. April the 10th. And April the 16th, both of them conditions of bond. We have Christopher Bryant back here. It's Christopher Bryant, but say after Christopher Bryant, who we?
We might just have a negotiation on April 3rd because they won't close the courthouse. Either way.
okay. All right.
Dog days.
Christopher Bryant,
Yes, Your Honor.
good morning. You're here on 26 CR 009 for arraignment. Were you born in 1989?
Yes, Your Honor.
Last four digits, social security number 3558.
Yes.
You're represented by counsel. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance, first degree failure to maintain the insurance, no registration plate, no expired plates, drug paraphernalia, and speeding. Counselor, you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. Mr. Bryant, requiring the Commonwealth to provide you with information to prepare for your defense. See no reason that you can't remain on your same bond. Now,
Yes.
he hadn't posted a bond yet.
He posted 5,000 in district court and it's not got.
What's the bond here?
Your Honor, this is the first time.
I know, what was on the warrant?
$15,000 surety.
$15,000, and he's got a 5,000 cash downstairs.
Yes, sir.
I'll take the $5,000 cash and leave it there. Okay.
Yes,
So transfer it over. You're to be back here on March the 6th for negotiation and March the 19th. You're under a curfew. You go to work, church, doctor. Okay, thank you.
Yes, Your Honor.
Thank you, Judge.
Yeah. Justin Bunch. Justin Bunch. Well, are you Justin Bunch?
Sir, I am.
Okay, good morning.
Good morning.
This is 25 CR 0044, Commonwealth of Kentucky versus Justin Bunch. Mr. Bunch was born in 1982.
I was.
Last four digits of social security 5069.
Yes, sir.
You have an attorney here today?
Yes, sir.
Okay. We're here for a pretrial conference for you. We got, what's the Commonwealth?
Well, I had a motion for a pretrial conference scheduled, and Mr. Parent told me that there's no need for one.
He's rejecting the offer that you gave him, the 7.5.
Yeah.
If you think that there may be a way
Ready to
to
set a trial date then?
open it.
Get your calendar with you.
Yes, sir.
Is he being indicted on trafficking or possession?
Traffic.
Thank you. I have possession then. Yep.
He was initially charged with possession and then he got indicted on trafficking.
Yeah, there's one issue I've got. I'll have to have the lab examine one bag, which turned out to be 3.628 grams of methamphetamine. And there was another bag that weighed 3.995 grams, that there was no analysis done. So if we're going to have a trial, I'll need to get the analysis done on both samples.
Okay, well, let's just set it for probably for April sometime, for a negotiation date,
Let's do April 16th, and if it's not, and do the 10th, if it's not settled, and I'll have the lab report, we'll get a trial date in April, if that's all right.
yeah, what was the negotiation date?
April 10th at 9 a.m.
April 10th, and April the 16th court dates. Both of them can issue your bond. Catherine Carmichael.
Thank you, Your Honor.
Yeah. Catherine Carmichael. Commonwealth versus Catherine Carmichael. Are you Catherine Carmichael?
Yes, sir.
Good morning. You're here on 25 CR 0075.
Yes, sir.
Carmichael, were you born in 1982?
1992.
92.
Yes, sir.
I say 82,
Yes, sir.
1982.
Yeah, it's 92.
Okay. You just gained 10 years here, so. The last four digits, social security number 5220.
Yes, sir.
You have an attorney?
I actually just yesterday paid a retainer for Ted Lavitt out of Lebanon. He had something else that was going on with the schedule today, or else he would
You
have
want
been
to
down
just
here.
dismiss, Mr. Lavitt's going to represent, you want to just dismiss the case?
yeah.
That reminds me of the old Jerry Clark joke about the coon in the tree with the lead.
Yeah.
Yeah, he had some other court today in Lebanon that he had to take care of.
We're sorry you're inconveniencing.
Yes, sir.
Yeah. He was quite prominent at the prosecutors conference, Mr. Lavitt was, on the Crystal Rogers case.
I'm sure he was.
Yeah.
He needs to be present on negotiation day
Okay,
on March the 6th.
Okay.
And the next court date are March the 19th, and both of them are conditioned to your bond.
okay.
We'll write that down for. Can you remember that?
6/19.
Yeah,
Yeah, I
March
got it.
6th, 19th.
Okay. So,
Okay,
thank you.
and if he can't be there on those days, you need to get somebody else, because he didn't call, he didn't do anything about being here today, so I'm not gonna put up with that, okay?
And I think she needs to be at the negotiation, whether he is or not.
You need to be there both ways with another attorney if he can't be there, because this is gonna start going supersonic fast on you, okay? Yes.
Yes.
Jonathan Clark. Commonwealth versus Jonathan Clark, 25 CR 0076. Are you Jonathan Clark?
Yes, sir.
Good morning. Were you born in 1974?
Yes, sir.
Last four digits, social security number 6109.
Yes, sir.
You're on a pretrial conference. You have an attorney?
No, I need appointed attorney.
Okay, I'm gonna appoint public advocacy, and then we can do an affidavit after he gets finished with that.
Sorry, Your Honor.
Yeah. This is your new client, Mr. Jonathan Clark.
Yes, sir. We will be having a conflict him out, Your Honor, but
Do what?
we're going to be conflicting him out to separate counsel.
He's a co-defendant with Miss Carmichael.
Okay, well, you can stand in for arraignment then, can't you?
He was arraigned, Your Honor, last month, where we were not appointed. We were just appointed for arraignment. And then he was given negotiation date and today.
To appear with an attorney.
Why didn't you get an attorney?
I don't have the money to
You
get
didn't
one.
have the money last month either. We could have.
Well,
replaced
I've been
somebody.
in talks with one, but they want too much money. I ain't got that kind of money, so.
Okay. Well, we'll set the negotiation day for March the 6th and the next court appearance for the 19th. And y'all get him a conflict attorney to meet with him.
Yes, sir.
You're gonna have to take this thing seriously. Carolyn rather, it says Carolyn Copus. Carolyn Copus,
She's in Barrington. She's listed under a different name in Barrington.
move her down. Move,
Land, Your Honor, I believe is what they've got her listed as.
okay. Carolyn Copus lands,
Bland.
land.
She's gonna be on the phone.
Okay. Jared Hopkins. Commonwealth versus Jared Hopkins. 29 CR 0012. Are you Jared Hopkins? Good morning. Were you born in 1982?
Yes, sir.
Last four digits, social security number 6546.
Sir.
You're here for arraignment and to enter a plea.
Your Honor, he's not gonna accept the rocket docket, so I've advised, Mr. Stockton, I believe he is, indicting him on the grand jury is gonna be presented.
And that's an interesting question for me, because he signed the information. Does he want to go ahead and proceed on the information, or do you want us to go through the grand jury process today?
I'm gonna let him proceed on the information. That doesn't prejudice him in any way. He agreed to proceed on the information. We'll proceed on the information. Now, he doesn't have to go through the rest of the agreement. We'll just handle it like a normal case.
When indictment comes back, we'll dismiss that.
It won't be necessary to have an indictment. Do what?
They'd already planned, they're presenting it today.
Well, we may not have got through yet, so we'll see.
Well, I'll just arraign him on this and we can amend it by anything that they have in the indictment then. This is, you acknowledge the identity of your client, receipt of the information, waive formal reading of the information, enter plea of not guilty, reserving all pretrial motions, correct?
That's correct.
Okay. We will set this on March the 6th at 9 a.m. for negotiation and March the 19th for the next court appearance. Both of them are conditioned to bond.
Yes, sir.
Yeah. Grady Jones.
Judge, we're still working on the paperwork.
Joshua Pettigo. Commonwealth versus Joshua Pettigo, 25 CR 0073. Are you Joshua Pettigo?
Yes, Your Honor.
Good morning. Were you born in 1986?
Yes,
Last four digits, social security number 4930.
yes, sir.
What does the Commonwealth have in this case?
I've got, it's supposed to be pretrial diversion under Miss Hill, but we've got Mr. Carter here now. My notes must be in error.
Yeah, we have the type of executed judge.
What kind of case is this?
It's a, when we have the file. Pettigo. Yeah.
It's a trafficking, tertiary first offense, or equal to two drug administrative unspecified possession, secondary and description of it.
Yeah, and we've agreed to diversion. It was Adderall, was the pills that were confiscated. The bar, I mean, already.
It's Adderall, like a.
It's a controlled substance. It just has a medical value, unlike.
Yeah,
And
use it for ADHD and stuff like
he had
that.
about 27 pills. There wasn't any evidence of trafficking. He claims that he had it for a long time. The probation will tell the tale of it.
Most have been tendered says that you wish to enter guilty plea today. Is that correct?
Yes,
Are you currently under the influence of drugs or alcohol?
no,
Is this plea freely and voluntarily given?
yes,
Are you the same person named in the indictment? Can you discuss the charges with your attorney? Are you satisfied with his advice?
yeah,
You reviewed the evidence Commonwealth has against you. You believe you're fully informed about it.
yeah,
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution.
yeah,
I need to know that you understand those rights before I can accept the plea. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented in the counsel at your jury trial. You have the right to confront and cross-examine all witnesses called, testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond reasonable doubt that you're guilty of charges against you. Understand that by hearing and plea of guilty, you give up all those rights. You understand that?
Yes.
Now, we consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. And I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No,
Have you had any felonies in the past 10 years?
no,
Are you currently on probation?
no.
You understand if you fully complete the diversion programs, the charges with withdrawal diversion, you'll be eligible to get them expunged. You understand that? You understand if you do not fully complete the diversion, you'll be brought back before the court. And if I find that you violated, I will void the conversion, schedule a sentencing hearing, and you be a convicted felon. You understand that?
Yes.
Okay, Mr. Stockton, what's the offer?
Your Honor, he would be plead guilty to possession of a controlled substance, first degree, 3-year sentence, pre-trial diversion for 5 years. He would maintain gainful employment and pay court costs at discretion of the court, and the diversion would be supervised for 5 years.
Okay, what is the court cost? You need some time to pay that.
Yes, Your Honor.
I'll let you pay it at $40 a month, starting 30 days from today, okay? And this offer is what you agreed to?
Yes,
And you are pleading guilty because you did commit the acts charged in the indictment.
yes,
Doing so of your own free will.
yes,
You realize if you get revoked and you be a convicted felon, that could be used against you in the future. Yes. This explains still your desire. Signature on the document.
yes, sir.
I accept the agreement, sign the diversion order, and including the court costs that I gave you. You don't need to meet with a probation parole officer.
Thank you, Your Honor.
Yeah. Joshua Pettigo. We already did Gravy Jones, Joshua Pettigo, Charlie Pickering. Well, just mark off Gravy Jones. Charlie Pickering. Are you Charlie Pickering? Good morning. Do you have an attorney?
Yes, sir.
Why is that?
I don't know. I asked for an attorney for one to be appointed to me.
Who did you ask?
The post.
Have you been, were you in district court on this? Judge, do what?
He was appointed the DPA downstairs. And
He was?
Yes, sir.
I'll continue that appointment. You're here for arraignment. You have a right to remain silent. The grand jury of Monroe County is returning the indictment, charging you with theft, unlawful taking of disposition, more than 10,000, but less than $1 million. Do you understand what the charge is? Okay. You acknowledge, counsel, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
You have an affidavit on Mr. Pickering from district
You're not
court.
sure, but I can fill out one.
I want an affidavit for that on it.
Yes, sir.
See if what I'm gonna do about charging the fee. I'm signing a reciprocal discovery order. Commonwealth have to give your attorney information prepared for your defense. You be here on March the 6th. Negotiation in March 19th at 9 a.m. on both days.
Yes, sir.
Both of them are conditioned to your bond.
Yes, sir.
Thank you, Your Honor.
Okay. Letitia Troball. You had BPA. I'll continue that appointment.
Just got one.
Commonwealth Kentucky versus Letitia Troball. 26 CR 005 here for the purpose of arraignment. Miller Roger remain silent. Grand jury of Monroe County, excuse me, has returned an indictment charging possession of drug paraphernalia, failure to maintain insurance. To have to help you prepare for your defense. You'll be here on March the 6th at 9 a.m. for negotiations and March 19th for your next court date, okay? Is there anybody else here out in the crowd that came here for the purpose of being arraigned or if not, we'll move to Hardin County Detention. Hardin County Detention, are you on the line?
Yes, Your Honor.
Okay, this is Commonwealth of Kentucky versus Matthew Burkhead. Your attorney is present, Mr. Burkhead. Were you born in 1993?
Yes, sir.
4 digits, social security number 6665. Was a Commonwealth
Yes, sir.
verification.
Your Honor, Mr. Burkhead has a 10-year sentence, possession of a handgun by a convicted felon, 2 counts. He has a new felony arrest in Hardin County. I guess that's why he's in Hardin County for possession of meth. My understanding, the last time we continued this because he was having a preliminary hearing or something coming up in district court. I don't know if he's been indicted up there or what.
So the prelim got moved to tomorrow, and that's why Hardin County transported him. It got reset, so he'll be having the prelim tomorrow in Hardin.
So I didn't subpoena the witness because this happened in Hardin County. I didn't subpoena any of the officers. If the court wants me to do that next month, I can, or if you want to just wait and see what Hardin County does.
May I speak?
Matthew, I'd advise not to. Anything you say can and will be used against you.
I understand that.
So we can still work to potentially get you a treatment bed.
Yes, I was gonna say, before I got transported up here, I was assessed down there in Monroe, or in Barron County. I'm thinking, that's kind of the route that Hardin County's gonna go. I'll know for sure tomorrow. More on that.
Our alternative sentencing worker has assessed him, so we're working to see what her recommendation is before we bring that to Mr. Stockton.
The Commonwealth here.
That's enough. That's enough. Okay, you talk to him.
I'll need to confer with Mr. Young, who's the Commonwealth attorney in Hardin County, and see what he wants to do.
Okay, that'll be fine. Well, let's just put this on the docket for next month,
Yes, sir.
March the 19th. We'll see what happens up there, and then we'll have to talk to you on March the 19th. Hardin County, you're released, excuse. Thank you for contacting us. Now we'll go to Barron County in about 10 minutes here. Let's go off the record. You see Miss Bardwell, Judge, we're ready to go on her. Well, we'll take her up first thing. Commonwealth attorney just stepped out. I think he had the restroom. Okay. Ricky Birdwell, I'm gonna come around. For sentencing.
Yes, sir, Judge.
Are you Ricky Birdwell?
Yes, sir.
Good morning.
Morning.
You're here in 25 CR 0053. Are you, were you born in 1979? Last four digits, social security number 0838. Have you had an opportunity to look at the pre-sentence investigation report and probation parole?
Is that what we?
Yeah.
Yes, yes.
Is it substantially correct? Counselors, any reason this lady should not be sentenced today?
No, Your Honor.
Well, plead guilty to trafficking and controlled substance, first degree, first offense, methamphetamine over 2 grams. She shall receive a sentence of 5 years, probated, however, 5 years supervised. She shall enter and complete the specialty court. Has she been voted into specialty court yet?
Yes.
Okay. She shall remain incarcerated until the morning of orientation. Has she been oriented yet?
I don't know about that, Judge. I think
The orientation, we don't know that. That Mr. Gray scheduled that.
Okay. She'll be, remain incarcerated until the orientation. What are the court costs?
$185.
You need some time to pay that? First $30 a month, first payment 30 days from the date you're released.
Okay.
Okay,
Thank you.
thank you very much. Jeffrey Blakely. Commonwealth versus Jeffrey Blakely. Are you Jeffrey Blakely?
Yes, sir.
Good morning. You're here on 25 CR 0068. Mr. Blakely, were you born in 1988?
Yes, sir.
Last 4 digits of your social security number 4210.
Yes, sir.
Here for a pretrial conference and a motion to revoke bond. What does the Commonwealth have to say?
Your Honor, when we negotiated this case, Mr. Blakely owed, I think, it's about $1,600 restitution. I can't remember the amount. Yeah, $1,271 restitution. And I told Ms. Hill under the new law on the criminal mischief, if he would pay that off, that I would dismiss the case. Well, subsequent to that negotiation day, he picked up another criminal mischief charge, and I didn't know anything about it as far as what type of case it was. And that's the reason I filed the motion to revoke bond. But however, he has paid the restitution on the case here in circuit court. So that leaves me in a quandary as what to do. I think I will go ahead and do what I told them to do because my word's not much, but I try to go by it. So
What is the new case? What are the charges in the new case?
It's a criminal mischief, Your Honor, involving it. I don't have very much information regarding it yet, but it does look like it had something to do with a car accident, maybe through a fence.
So my suggestion is if the court lets him out because he paid this off, he might want to get that paid off before it goes to the grand jury.
Here's your citation.
Yeah, he's alleged to run through a fence, damaging multiple fence posts, 2 mailboxes, and a south central telephone box. There's no amount of restitution given on the citation. Trenton Tooley's here. He worked the case. I don't know. You can tell us about this.
Yeah, I was there, Your Honor. He was involved in a collision there on the 53.2 Silver Lake Road. I made contact with the property owner, with the deputy that's working the case. I believe the estimated estimate was like $4,000 to $5,000 roughly. There were several fence posts and some woven wire fence.
Is he being held on the district court case too?
He has $18,000 cash bond.
I would suggest, Your Honor, I would move to dismiss this case and then I'll probably indict him on the other case and go from there, since he has made this case.
So he can get out then, right?
No, he won't. He's got a bond in district court.
On this one, maybe.
On this new case.
On the charge that we've got, he's out.
I don't.
He's in on the district court.
It's the bond from the district court.
We dismissed this case here in circuit court He'll be held subject to the action of the grand jury.
I will tell Mr. Blakely and his counsel that there'll be no more dismissals.
He's out on, he's only being held on the district court. He posts the bond in the circuit court.
Okay.
So
And the circuit court case is dismissed now. Okay,
There'll be a new one pretty soon.
thank you very much.
Thank you.
Aaron Crane. Mr. Blakely, did you understand Mr. Blakely, you understand the case here in circuit court has been dismissed because you paid those damages off. They've got the case where the officer said you were involved in some kind of vehicular thing. It got some fence posts down, so you need to talk to your attorney about that. It's still in district court. So you're held in jail on your district court, not on the circuit court now, okay?
Okay.
Okay, thank you.
Thank you.
Aaron Crane. Are you Aaron Crane?
Yes, sir.
Good morning. This is 25 CR 0066. You're here for the purpose of arraignment. Mr. Crane, were you born in 1987?
Yes, sir.
Last four digits of your social security number 1208.
Yes, sir.
Okay, you have an attorney?
Kevin Parrott was my attorney, I thought.
He was appointed down in district, Your Honor.
I'll continue the appointment. Here's your attorney coming on the screen there. You have a right to remain silent. Grand jury of Monroe County has returned an indictment charging you with operating a motor vehicle under the influence, fourth offense, and operating while revoked. You understand what those charges are?
Yes, sir.
Okay, counselor, you acknowledge the identity of your client, received an indictment, waive formal reading and arraignment, enter plea of not guilty, withholding on pretrial motions.
We do, Your Honor.
Okay, he's gonna be here on March 6th at 9 a.m. for negotiations and March 19th for the next court date. I'm signing a reciprocal discovery order. Requires the Commonwealth to give you all the information they have to help you prepare for your defense. Your attorney will be overseas, okay?
Your Honor, if I could address bond.
Go ahead.
Your Honor, at this time, I would request my client be ROR'd out.
Why is that? What's the charge you're pushing on this, Mr. Stockton?
Yeah, we've had him in NCIC, Your Honor, since January of 25.
and I think we had to be extra.
And I believe we had to extradite him from, I'm trying to read this. Where did he come from?
March the 6th and March the 19th.
Don't have what
Willie Deans. Commonwealth versus Willie Daniels. Are you Willie Daniels?
Yes, sir.
Morning.
Morning.
You're here on 25 CR 0058 for a pretrial conference, but you're also here for arraignment on 26 CR 002. Were you born in 1997, sir?
Yes, sir.
Last four digits, social security number 2134.
2134.
Yeah, that's right. Okay, you have a right to remain silent. Your attorney, Mr. Bell, is here. Grand jury's returned an indictment charging you with trafficking, controlled substance, first offense, possession of drug paraphernalia, endangering the welfare of a minor, 2 counts, criminal littering, traffic controlled substance, first degree, first offense, cocaine, being a persistent felony offender in trafficking charge, and a persistent felony in cocaine charge. You understand what the charges are?
Yes, sir.
Counselor, do you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'm gonna sign a reciprocal discovery order here, sir. Requires the Commonwealth to give you the information they have. So you can prepare for your defense, negotiation day on
Please,
March.
court judge, we've got we negotiated a plea in this case, both cases.
Okay. Is this a felony plea?
Yes, sir, Judge.
Okay, I've just been informed by your attorney that you filed a motion to enter a plea today. Is that correct?
Yes, sir.
Are you under the influence of drugs or alcohol now?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the two indictments that we just went over?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
You discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
View the evidence the Commonwealth has against you, and you're fully informed about your case.
Yes, sir.
That you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you fully understand those rights. I'm gonna go over them at the end of it. I'll ask you, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that entering this plea, you give up all those rights. Is that correct? You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of law, range of penalty provided by law. However, before making this decision, I will await the pre-sentence investigation report, probation, parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
Mr. Stockton, will you come around to the Commonwealth's offer?
Your Honor, in 26 CR 2, he'll plead guilty to trafficking in a controlled substance, first degree methamphetamine, a C felony, to receive a sentence of 5 years. Also, in that case, he'll plead guilty to trafficking in a controlled substance, first offense, receive a sentence of 5 years. And also in that same case, those two sentences shall run concurrently for a total of 5 years to serve. In 25 CR 58, he'll plead guilty to tampering with physical evidence, receive a sentence of 5 years to serve. All sentences shall run concurrently for a total of 5 years to serve. The Commonwealth opposes probation and shock probation. He'll receive credit for time served. All evidence will be destroyed, and all remaining charges in the two cases will be dismissed.
Is that your understanding of the Commonwealth's recommendation, sir?
Yes, sir.
Pleading guilty because you committed the acts charged in the amended indictment, correct?
Yes, sir.
On your constitutional rights, that explain to us it's still your desire to give up those rights, enter guilty plea and allow the court to fix your punishment within the range permitted by law. You understand, is that correct?
That's correct.
You understand by entering this guilty plea, any future convictions of felonies could be enhanced under persistent felony offender law. Do you understand that?
Yes, sir.
And will you bring the document over here and let me show him the signature? And that's your signature on the docket right there, document.
Yes, sir.
I'll agree to accept the order pre-sentence investigation report. I guess you just turn this in now. Okay. Pre-sentence investigation report and have sentencing on March 19th. Okay.
Well, I was hoping to waive final sentencing if possible.
He did ask me yesterday to waive his PSI and go ahead with his final sentencing. He becomes state inmate judge and be able to go ahead and start working. And
I cannot wait. If he was already a state prisoner when this happened, I can't wait. Okay.
well, we'd make their threat, Judge. Thank you.
Thank you.
You have a good day, Judge.
You too. You're leaving us? James Dickin. Commonwealth versus James Dickin, 26 CR 0001. Mr. Dickin, you're here for arraignment. Were you born in 2002?
Yes, sir.
Last four digits of social security, 1899.
Yes, sir.
You have counsel here today. You have a right to remain silent. The grand jury of Monroe County has charged you with murder. Do you understand that charge?
Yes, sir.
Counselor, do you acknowledge the identity of your client and the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
I do, Your Honor.
Okay, now, because of the nature of this action, you want to put it out a little farther, Mr. Stockton?
Yes, Your Honor.
Uh,
Unless Mr. Garrett's wants speedy trial.
Would not ask for that.
Okay.
yeah,
Yes.
April the 16th will be the next court date. Negotiation days, what day are they?
April 10th.
April 10th and April 16th.
That'd be fine.
Okay, and I'm signing a reciprocal discovery order, sir, that requires the Commonwealth to provide your attorney with information they have to help you. Okay,
Yes, sir.
he'll be over to see you. Keith Galliser. Commonwealth versus Keith Galliser. 18 CR 0007. Are you Keith Galliser?
Yes, Your Honor.
Yeah, good morning. Were you born in 1991?
Yes, sir.
That's four digits, social security number 4306.
Yes, sir.
On 18 CR 0007 on a probation application. What does the Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession, motion to revoke. The final thing he's gonna stipulate.
Correct.
Okay, stipulate. We'll just go ahead and enter the revocation order. Okay,
Thank you.
thank you. Teresa Harris. Teresa Harris. Are you Teresa Harris?
Yes, sir.
Good morning. This is 26 CR 0010. Were you born in 1979?
Yes, sir.
The last four digits, social security number 6396.
Yes, sir.
This is here for arraignment. Is this a rocket docket thing? I'll go ahead and arraign her on information. The information charge that you committed the offense of possession of controlled substance, first degree unspecified. You understand what that charge is?
Yes, sir.
Okay, do we have a plea agreement?
We do.
The motion been entered says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that appeared in 26 CR 0010?
Yes.
You have certain rights under Kentucky and the United States Constitution. But before that, I want to find out, have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Are you fully informed about your case?
Yes.
Now, I'm going to go over your constitutional rights before I accept a plea. At the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. Right to be represented by counsel at your jury trial, to confront and cross-examine all witnesses called to testify against you. Right to produce the evidence. Right to have call witnesses in a process issue to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand, by entering this guilty plea, you give up all those rights. You understand that? Do you understand that? Constitutional right. Okay, now I may consider the Commonwealth's recommendation, but I may have give any range of sentence provided by law prior to entering receiving a acting on the recommendation. However, I will await the pre-sentence investigation and then enter a plea. Now, what is the In the event I don't accept that and oppose a harsher sentence, you have a right to withdraw your plea. What's the Commonwealth's recommendation in this case?
Yes.
Oh, we got the wrong one.
Yeah.
She would receive a sentence of 2 years, pretrial diverted for 3 years on the charge of possession of controlled substance first degree. She would enter and complete the Monroe County Specialty Court. She'd be released from the jail on the morning of drug court orientation, receive credit for time served. She would obtain and maintain gainful employment or do 30 hours community service. All evidence be destroyed, and she would pay court costs at the discretion of the court.
So this is diversion.
That's correct.
Okay, I want to ask you a few questions, see if you qualify for diversion. Previously been diverted in the last 5 years?
No.
Have you had a conviction of a felony in the last 10 years?
No.
Are you currently on probation?
No.
Okay, you understand if you complete the diversion agreement, charges will be dismissed, pretrial diverted, you have them expunged. But if you fail to successfully complete the diversion program and it's revoked, I'll have the pre-sentence investigation board I referred to earlier done. You'll be sentenced to be a convicted felon, and any crimes you have in the future that are felonies in Kentucky could be enhanced for that. You understand that? Okay, you have the document with you. Who has the diversion agreement?
Turn the Sun document into Patty.
It would be in. And then that's all of that.
Is that your signature on there?
Yes. Yes, sir.
Okay, well, I'll accept the agreement, sign the order. What are the court costs in this case?
$165.
$165. You can pay that $40 a month in first payment made 30 days after you get released from jail.
Yes, sir.
Okay? When can she be released?
Orientation.
You get released on orientation for drug court.
We'll
They'll
have
come
to
up.
get her assessed, hopefully.
It hadn't been assessed, so they'll have to assess you, vote you into drug court, and do the orientation.
Thank you.
Thank you very much. Amber Henderson. Good morning.
Yes, sir.
Are you Amber Henderson?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last 4 digits, social security number 8584.
Yes, sir.
Okay, you're here on a pretrial conference. What's the Commonwealth have to say?
Your Honor, this is a case where we had to have her extradited from Tennessee. It's an older case. I don't know. Are you ready to proceed on it?
I just had discovery and Miss Henderson has made contact with my office. I haven't had an opportunity to go over discovery. There has been an offer given to, I have not had.
March the 19th, negotiation day will be March 6th, if you have enough information to negotiate by then, okay?
Thank you, Judge.
Okay. Larry Norris. Commonwealth versus Larry Norris, 26 ER 0008. Are you Larry Norris?
Yeah.
Good morning. Were you born in 1992?
Yeah.
Last 4 digits, social security number 1833.
Yeah.
Your attorney is here. You're here for arraignment. You have a right to remain silent. The grand jury of Monroe County charged you with possession of drug paraphernalia, public intoxication, and possession of a controlled substance, first degree, third offense. You know what those charges are, sir? You understand those charges? Okay, counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll set negotiations for March 6th, court's appearance for March 19th. I'm signing a reciprocal discovery order, sir, that requires the Commonwealth to give you information to help prepare for you. Okay, thank you very much. Nathan Pettigo. Are you Nathan Pettigo?
Yes, sir.
Good morning. You're here on 26 CR 004 for the purpose of arraignment. Mr. Pettigo, were you born in 1983?
Yes, sir.
That's 4 digits, social security number 5642.
Yes, sir.
Grand jury of Monroe County's returned to indictment charging you failure to comply with sex offender registry second notice. You understand what the charge is?
Yes, sir.
Do you have an attorney?
No, sir. Need one appointed, please.
Okay, we'll let you do an affidavit and we'll appoint Office of Public Advocacy subject to review of your affidavit. Counselor, you heard Mr. Pettigo acknowledge his identity. You acknowledge receipt of the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order, sir, that will require the Commonwealth to give your attorney this discoverable information to help you prepare for your defense. You can come here on March the 6th at 9 a.m. for a negotiation, and March 19th is your next court appearance, both of which would be a condition of any bond. When are you gonna come over and see him?
Your Honor, first we have to determine who's gonna get this is gonna be appointed, so within the next 2 weeks, Your Honor.
What do you mean decide who's gonna be appointed?
So we take the blue sheets back. It could either be my
Does he
case
got,
or Ms. Hill's
does he
case.
have a conflict?
No, sir.
I just don't think he ought to wait for 2 weeks before someone talks to him.
Understood. We could definitely middle of next week would be
Okay, go over, somebody be over within the week, okay? Talk.
Yes, sir. Yes, sir. Thank you.
Okay. Eric Reese. Are you Eric Reese?
Sir.
Morning. We're on 26 CR 00011. Mr. Reese, were you born in 1986?
Yes, Your Honor.
That's 4 digits, social security number 4148.
Yep.
You're here today to be arraigned and enter a plea on the rocket docket. Is that correct?
That's correct, Your Honor.
The Commonwealth attorney charges that the defendant committed the offense of possession of controlled substance, first degree methamphetamine against peace and dignity of the Commonwealth. Mr. Bailiff, will you acknowledge the counsel, will you acknowledge the identity of client, receipt of the information, waive formal reading and arraignment, enter a plea of not guilty? Is that what he's gonna do?
Yes, sir.
Is this a felony plea?
Felony plea for pretrial diversion, Your Honor.
It's a pretrial diversion. Mr. Stockton, what's your offer?
The possession of a controlled substance, first degree, first offense, receive a sentence of 2 years, pretrial diverted for 3 years, supervised. He'll enter and complete the Monroe County Specialty Court, be released from incarceration the morning of drug court orientation, receive credit for time served, obtain and maintain gainful employment once he's released, agree to have all evidence destroyed and pay court costs at discretion of the court. And this is another one, Mr. Elliott's going to have to schedule a time and go assess while he's in jail.
Okay, you heard this, a motion's been tendered, said you would wish to enter a pretrial diversion today. Is that correct? Please. Sir, can you hear me?
Yes, sir.
Motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Okay, are you currently under the influence of drugs or alcohol?
Not.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person that we just identified in 26 CR 00011?
Yes, Your Honor.
Have you had an opportunity to talk to your lawyer? Are you satisfied with his advice?
I am.
You reviewed the evidence the Commonwealth has against you. Believe you're fully informed about your case, do you?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. If at any time while I'm reading the rights, you have a question, raise your hand, okay? If not, I'll ask you then if you understand. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor and compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to make a Commonwealth prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering a guilty plea to this, you waive those rights. Is that correct?
Yep.
I may consider the Commonwealth's recommendation, or I may apply any range of sentence provided by law. In the event that you do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. You understand that?
Yes, Your Honor.
Okay, I'm gonna ask some qualifying questions. You understand if you successfully complete the program, the diversion, your case will be dismissed pre-trial diversion. You can have your record expunged. Now, have you been previously diverted in the last 5 years?
I'm not.
Have you had any felonies in the past 10 years? What was that?
I couldn't understand, Your
Have
Honor.
you had any felony convictions in the last 10 years?
No, sir.
Okay. You understand that if you do not successfully complete the program and you're brought back in front of me, I will have a pre-sentence investigation report done and you'll be sentenced, you'll be a convicted felon on these charges here. You understand that?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended down? You doing so of your own free will?
Yes, sir.
Know your constitutional rights. Is it still your desire to give up the rights? Enter a plea of guilty and allow the court to fix your punishment within the range permitted by law.
Yes, sir.
Now, let me show you your signature here. Is that your signature right there?
It is.
Okay. Well, I will accept the plea agreement. What's the court cost?
$165.
Court costs $165. I'll let you start paying $30 a month, 30 days. The day you're released. Okay, that'll give you some time to get back on your feet. Okay.
Thank you, Your Honor.
You going to drug court?
Yes, sir.
You know, they're going to come over and do an orientation interview and that sort of thing.
He
So I
hasn't been
understand.
assessed.
Yes, be assessed.
Okay, you have to be assessed, then they'll come over and vote on you and do an orientation. So your attorney can explain that in detail to you. Okay? Thank you very much. Tamara Stamper. Tamara Stamper.
Hello, Your Honor.
Hello. Ms. Stamper, you're here on 25 CR 0010. Were you still born in 1985?
Yes, sir.
Last 4 digits, social security number 1699. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah, I did. Yes.
Substantially correct.
Yes.
Counselor, is there any reason why this lady should not be sentenced today?
No, Your Honor.
Following a plea of guilty to operating motor vehicle under the influence, fourth offense, she received a sentence of 5 years, served 180 days, balance probated 5 years, probation to be supervised. Is that correct?
Yes, Your Honor. And y'all found a placement for her?
We do not have a bed yet because she has a hold out of Fayette County still, so we're waiting on that.
Okay.
Okay, since you have that Fayette County holder and things, I'm gonna waive the court costs.
Okay.
Good luck to you, Jim.
Okay, thank you so much, Judge. I appreciate it.
Yeah, see you now.
Judge, that was a DUI.
Okay.
So
Wait, they got it.
that you can't learn.
Yeah, I'm sorry, that was a DUI. I can't waive the fee. What's the fee portion? $425, you start paying $50 a month, 30 days after you're out of incarceration, okay?
Okay, I will.
Okay, thank you.
Wait, thank you, Judge.
Stephen Stewart. Hello. Commonwealth versus Stephen Stewart, 25 CR 0077. You are Stephen Stewart.
Yes, sir.
You were born in 1979. The last
Yes.
four digits of your social security number, 5141.
Yes, sir.
You have an arraignment here. You have a right to remain silent. Your attorney is present. The Commonwealth of Kentucky Monroe Circuit Court is charging you with human trafficking, possession or viewing material portraying a sexual performance by a minor, 32 counts, sodomy, third degree, incest, and rape, third degree. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty.
Yes, Your Honor.
Pretrial motions.
Yes, Your Honor.
Okay, we'll have a negotiation day on the sixth. Mr. Stockton, do you have any forensic things that would keep?
Yeah, we have the phone and the SD card. We've already gotten those back from the lab. That's got the child pornography.
Okay, will you be ready for negotiations on March sixth, you think? Okay, negotiation day here at 9 AM on March sixth, next court appearance on March 19th at 9 AM. Both of them are conditions of your bond. You had a bond reduction motion.
I did one thing on the record before we start with the bond reduction.
Around here, so we could
And I'm sure council's aware of this. If he wants to view the CSAM, the child sexual abuse material, he'll need to go to post and do that before we have the negotiation day.
I have a number of records that I'm accessing as well that I want to provide to the Commonwealth. I don't know if I'll have them by the 6th of March, but.
Well, we'll just schedule it for the sixth, and if you don't have me, y'all can send me an agreed order, take it over to the next month, okay?
Yeah, and we filed a bond motion.
Go ahead, tell me.
And Judge, my client's has no criminal record. He turned himself in when these charges, he was made aware of the charges. He's worked at Century Fire for 21 years, making $26 an hour, steady employment. The alleged victim in this case has made multiple accusations of CPS, various people that were found to be untrue. I don't know what the exact evidence is yet on the images, but I'm told by the wife that they weren't on the phone, that they were on cards that were in the house where there were multiple people. So he's presumed innocent until proven guilty, of course, as the court is still, well, I know the charges are, when you look at the charges, I understand the court's initial position, but given this guy has no criminal record, turned himself in, long steady.
Who lives in the house with him?
His wife, I believe, lives in his house with him now.
Was the victim living in the house before this happened?
Yes, she was. She was living in the house. And
where does she live now?
I think she's married. She lives at another residence, Judge.
Yeah.
I don't think she's at the house.
Sign a reciprocal discovery order, so they'll have to give you what they have for discovery.
Thank you, Judge.
What's your position?
Your Honor, I can call Trooper Tooley as a witness if I need to. The human trafficking is based on alleged allegations by the victim that Mr. Stewart would give her different things in order for her to have sexual relations with him. Now, as regards the child pornography, the SD cards, Mr. Cottle's right, the child pornography is on the SD cards, but they were given to him by Mr. Stewart. And according to Mr. Tooley, he's reviewed those cards. And there'll be an image of child pornography on there, and then there'll be a selfie of Mr. Stewart on the card. So we don't have any doubt that they were his cards that he gave with the child pornography. So that's our position. So I don't think it's as unsubstantiated as I think.
There's a sodomy charge here.
Yeah, that's with the defendant's stepdogs.
And we have at least 2 CPS investigations that were conducted because of her complaints and found to be unfounded. And in addition to multiple other accusations this individual has made against other people in the family. And
I'll tell you, I'm not going to reduce the bond today, but I will give you an opportunity to have a hearing on it. It seems like you do have some issues that could be brought up, and I don't doubt what you're saying, but I can't really make a finding without some sworn testimony.
Yes, Judge, I'll put the mother on the stand and she can testify at length. That'll be fine. And
You won't be able to furnish me what you got over here. Yes, yes, absolutely.
Let's just go ahead and schedule a hearing on March 19th, okay?
Sorry.
Yeah, and so you want a hearing before there's a bond reduction, even if there was an ankle?
He furnished me his exculpatory information, and I'll have Mr. Taylor be prepared to have somebody out here with the.
We will absolutely have it here on the 19th.
Yeah.
Okay, okay, thank you very much.
Thank you, Judge.
Yeah.
Sorry.
Is there anyone else over there? Your attorney will be over to see you, sir. Is there anybody else at the Marion County Jail?
I've got a Carolyn Bland that they added to the docket, Your Honor.
Okay, Carolyn Copus Bland.
Yes, Your Honor.
Are you Carolyn Copus Bland?
Yes.
Okay, we're going, by agreement, we'll amend the indictment, Mr. Stockton. Okay, do you have an attorney, Ms. Bland?
No, I do not, sir.
I'm gonna appoint public advocacy and we'll back it up with a affidavit.
Well, that's just a.
They've already left.
Pardon?
They've already left.
Who's already left?
The DPS.
Well, somebody needs to go get them. Call downstairs, call downstairs. We got a phone as they're leaving.
It's got too many favorites. My problem. What's going on this book?
What's she charged with?
Assault, fourth degree minor injury, and burglary, second degree.
Hey, Candace, y'all still got one more case up here. You know, Carolyn Bland. She's in Marion County Jail. So you'll be back up here in a few minutes.
Carolyn Bland. I just couldn't.
Oh, okay, thank you. She's already exited the building, just made it down the road, but she's turning around and coming back.
Okay, let's go off the record.
We got,
Go back on the record here. Who you got? Well, Ms. Bland will be right back to you. The public defenders had left the building. They're on the way back, so.
Okay, you want me to sit down?
Yeah, you can sit down.
Grady Jones.
Okay.
Real quick.
Yes.
I'm sort of this here. I didn't know it was too much.
Commonwealth versus Grady Jones, 25 CR 00055. You are Grady Jones.
Yes, sir.
Born in 1960. Last four digits, social security number 9041. Is that correct?
That's correct.
What does the Commonwealth have in this case?
We had a felony plea.
Okay. Get behind, let your client behind there. The motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely voluntarily given? Freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0055? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm gonna
Yes,
go
sir.
over them. At the end of it, I'll ask you.
Yes.
Okay?
Go over.
You have the right not to testify against yourself. No one can make you say anything. The right to be tried by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charge against you. You understand that by entering a plea of guilty today, you give up all those rights. You understand that?
Yes, sir.
Now, we consider the Commonwealth's recommendation, but only applying range of sentence provided below. I have to accept the recommendation. Prior to accepting any recommendation, I'll await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. You understand that?
Yes, sir.
Give y'all a step to your left. Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, Mr. Jones would plead guilty to the amended charge of possession of a controlled substance, first degree, first offense. He'd have 1 year to serve. The Commonwealth opposes probation, shock probation, and it's been admitted from the plea. And I want to get it clarified with Mr. Garrett. I think under statute, it has to run consecutive with the 20-year sentence. He's on parole. And that's not in the plea, but I just want you to understand that'll be the Commonwealth's recommendation.
That's correct.
And evidence in this case to be destroyed.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended down?
Are you pleading guilty to the amended charge of possession of controlled substance?
Yes.
Okay. Are you doing so of your own free will?
Yes.
Okay, you know your constitutional rights that explained to us, it's still your desire to give up those rights, enter a plea and allow the court to fix your punishment. Do you understand that entering a plea, any future convictions could be enhanced in the persistent felony offender law because of this plea? Do you understand that?
Yes, sir.
Is that your signature on the document?
Is that your signature?
Yes, sir.
Okay, I'll accept the agreement, schedule sentencing for March the 19th.
Judge, he is currently in treatment and is in his second month, completing his second month, going into his third, about to phase up. I've spoken with the Commonwealth. I think they're agreeable to setting the final sentencing once he completes it, and then he'll go into custody.
I'll agree if it's all right with the court. My understanding is he was placed in treatment through parole. Is that correct? Correct. And while he was on parole, after being placed in treatment, I don't know if he was indicted before or after.
After.
I don't know if it was before. I know when all this happened, he was on parole. And then he came in, sent into treatment as part of it.
How much does he lie?
3 months.
3 months.
3 or 4 months, yeah. So except whatever the court wants to do.
What do you want? What do you want?
He's wanting to delay sentences.
Well, if we can set it up, let him complete it and then come back for sentencing, Judge. He's doing well in the program.
That's what's gonna happen is once he's sentenced, he's gonna get his parole.
Correct.
Schedule sentencing for May 21st. Will I give him enough time?
I think he needs to be ordered if he loses treatment for any reason. Just report.
Absolutely. Absolutely. He's done well.
Put that in the order.
Thank you, Judge.
Okay. Okay. Does that conclude the docket? You got one other person here in the Barron County Jail. Okay, I call a case of Carolyn Hopus Bland. And I'm appointed to the Office of Public Advocacy to represent her. Ms. Bland, your attorney is back from a short sojourn. She's here and you have a right to remain silent. The grand jury of Monroe County returned an indictment charging you with assault in the 4th degree and burglary in the 2nd degree. I'm not asking if you did this or not. Did you understand what the charges mean?
Yes.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, preserving all pretrial motions?
Yes, Your Honor.
I'm signing a reciprocal discovery order requiring Commonwealth to give your attorney all the information they have about your, to help you prepare for defense of your case. So we will schedule you for March the 6th and for a negotiation date in March 19th. Okay.
Okay.
Now, what's her bond?
It's 10,000 cash or twice the bond.
Now, why is it that I set her bond that high? Remember? 10,000 cash or twice the property. Fourth degree assault,
Let me have that.
burglars.
Days.
Must have been something that triggered it. It's a little higher than usual.
It's under Bland, I think.
Oh, this is the problem, Your Honor, is she entered evidently either her husband is having an affair with a lady or is alleged to have an affair with a lady. And she went into this lady's residence and punched her in the face multiple times. She stayed this officer. She had no lies to tell. I went down to where my husband, Christopher Copus, was and started whooping Nellie. She expressed her anger toward Nellie and stated that they were related and she was trying to get her husband and lied about it. After being arrested, Bland State officer said, "I'm not done with her yet and it'll be worse when I get out of jail." So that's the problem. If she can cool off and abide by the law, she could probably get out.
Your Honor, can I say something?
Ms. Bland, I'm going to advise you not to make any statements at this time.
Okay.
Well, here your lawyer will come over and talk to you. So it's a little hard for me to let you out on bond if you went and assaulted someone, even though you felt like you were justified. And you say if you're gonna get out, you're gonna do it again. That doesn't give me a great deal of confidence that you won't do it again. If you say you're gonna, because you did it once. So your attorney gonna come talk to you, see if you can cool your jets down a little bit, okay?
Okay, do you know when she'll be here?
Wait. She ought to be here. When can you be over there, see her?
Your Honor, I will be over there as soon as I am able to get to the jail to speak with her. And after I have spoken with her, I will get with Mr. Stockton
Well,
about this.
she wants to know kind of a time frame.
Your Honor, unfortunately, I cannot give a time frame due to I do have other court schedules that I have to get to
I
within the next few
understand, but
days.
like by Christmas,
It will be before that, Your Honor. I would say probably within the next week.
she'll be over there within the week to talk to you, okay?
Thank you.
Thank you. Bye-bye.
That's everybody, Your Honor.
Ankle monitor from the time it happened. She didn't give him any problems, so we might do an agreed over.
We might do an agreed order to let you out if you go back on an ankle monitor.
Okay, that's fine.
And don't say anything else, but I'm gonna tell you something. If I sign an agreed order and you go back over there and get around that woman, you stay in jail for a long time. You understand what I'm saying?
Yes, sir.
Let it go. Okay, that concludes Barron County. We'll send you an order on this lady. That concludes our business, and thank you for being cooperative.
Thank you. Have a good day, Your Honor.
You too. Got a show cause docket here? Okay. Commonwealth versus Brittany Carnes. What we got on her? Brittany Carnes.
I've made notes.
Owes $1,240, revoked on 5/13/24. Released on 12. Okay, let's hold it down to a small roar over there because we're still on the record. Okay, she owes $1,240.
I'm not sure, did she say that or she on parole?
I'm not sure. I don't have her, so I'm.
She served out.
She served out.
Yeah. She had multiple charges over next year today.
Well, what do y'all want to do about it?
I say write it off. Yeah. Sorry. It's a show call.
She served out, okay.
Yeah, she
We
served out.
normally waive them after they've even reached their short probation period, if they're staying in there, go ahead and waive. She served out, she probably.
Do what? Some of it is restitution. How much is the restitution?
But I never paid anything with the rest of it. She's the one that took the money from the restaurant and kept saying her grandmother was gonna pay it and she never paid it.
Okay. Get a warrant for her and tell her she can purge herself by paying $1,000. All of it to be applied to restitution. Justin Hunt,
He normally pays if it's not his.
issue show cause warrant. He can purge himself by paying $400.
He's behind 200.
Yeah, 200 in the regular one.
He made his payment in January.
We'll just do it 200, purge himself for 200. Jody Murphy.
And I checked and she is in treatment.
Okay, put her out on the docket 2 months from now. Okay, we'll go off the record till, let's go off the record till 1 o'clock, is that right?
Yes.
Did you check on that woman's?
Well, I told Jim he gonna talk to
Good morning.
Can y'all hear me? Can y'all hear me now? No, that's not correct.
I can hear you, Judge Jeff Hoover.
Good afternoon, Judge. This is Phil Dyson. Can you hear me?
Did that take care of it?
I can hear you, Your Honor.
Okay. Okay, maybe we made some, Mr. Hoover, we owe you findings of fact, conclusions of law, and we
Yes.
said we would give it to you within 10 days.
Okay.
All right, I think they're drafted, but Megan had to leave because of illness today. Okay, thank you for your patience.
Yeah, have a good day.
Okay, JP Morgan Chase versus Wendy Shirley. Is counsel on the line for that?
William Rich on behalf of the plaintiff. It's a motion for summary judgment. The defendant's answer raises only the defense that financial hardship, which I don't believe really constitutes a defense, Your Honor. I don't believe there's any genuine issue of fact, and we would be entitled to judgment, Your Honor.
Do you have anything to say, young lady?
Yeah, I'm currently preparing to file for Chapter 7 bankruptcy. So due to financial hardship, and I'm just basically asking for a continuance.
Well, the deal is he's entitled to summary judgment and you can handle it in the bankruptcy court if you file it. So I'm going to give him the summary judgment and you know, as far as preparing to file is not filing. See what I'm saying?
Mm-hmm.
Okay. So if you electronically submit the judgment, we'll enter it. Okay. Thank you very much.
Okay. So what do I
Okay.
need to do? Like anything after this except just?
You need to go see somebody. If you're going to file bankruptcy, you need to file a bankruptcy judge. Okay.
Okay.
Bankruptcy lawyer. Okay.
Okay.
Thank you. Yeah.
Thanks, Judge.
Thank you. Mid-South Capital Partners versus unknown heirs of Michael J.
Hunter Jones for Mid-South Judge. This is my motion for leave to file an amended complaint.
Is this a tax lien case?
It is, Judge.
Okay. Okay, you just submit it electronically. We'll allow you to file an amended complaint, okay?
I'll do that. Thank you.
Okay, now, Mr. Dyson, what do you have on the docket? Does anybody else have anything on the docket that we've missed here?
Judge, I've got a Carrington Mortgage versus Bartley.
Your Honor, can you unmute me, please? This is Phil Dyson.
I don't know how to unmute you.
Okay. Can you hear me now, Your Honor?
I can hear you, yes.
Okay. Yeah, I'm here on the third continued status conference, and that Mr. Stevens said in August we served discovery. We haven't received any responses.
What case is this?
It's Osberg, Dyson versus Osberg, Your Honor.
See, I just don't have that on my docket here. I'm not saying it. Yeah, give us a case number on that. It's not on my docket.
You know what? Unfortunately, I'm not in my office.
Okay.
Give me a minute. My associate Laura Smith can give you a number, Your Honor.
Good morning, Judge. It looks like the case number is 25-CI-00020.
Okay, we'll pull it up here in a second. We don't have any notice on anything here. Is there a motion there? Okay, tell me who's on the line here, but is anybody else on the line about this case here?
Laura.
Laura Smith, I'm here with Mr. Dyson. I'm not from the other side. My understanding is that this was continued from the, I believe, January 29th hearing.
That's the court operative, the court order that is there raised to be complied within 20 days. So that's docket sheet.
The docket sheet says that I said that discovery was to be complied with within 20 days.
Nothing's been done, Your Honor. Crickets from Mr. Stevens. No discovery, no deposition date, which you ordered him to supply.
Was Mr. Wes Stevens on the other side? Is that who's on the other side?
That's correct, Your Honor.
Do you have a copy of any notice, any motion that you filed to be heard today?
No, this was a continued status conference hearing that you set.
I know, but I don't have anything on my docket sheet that was entered reflecting it. It could be my error, it could be something else. I'm just telling you what our docket sheet says, that he was getting 20 days and it doesn't give this date a specific date. So maybe there was an error in our entry here. My staff lawyer had to leave early today and I'm a little bit, Mr. Stevens is not here today. He's usually here and does a child support docket. Let me see.
What would you like to do, Your Honor?
I'd like for him to comply and let's advance, but what I like doesn't always happen. I've ordered it. Let me see if I can get him on the phone here.
I think he's at the prosecutor. Might be wrong.
Let me see if I can get him on the phone here. Hey, Wes, let me put you on a speakerphone here. We got that there was a discovery order I entered in a case and these folks thought it was going to be on a status conference today. I'm going to put you on the speaker, okay? Okay, he's on the speakerphone now and he can hear. What's the name of the case again, Madam Clerk?
Dyson versus Alford.
Dyson versus who?
Alford.
Alsberg.
Yes.
They say they haven't received any discovery on that, Wes. What's the story on that?
There is no excuse. I've got it typed up. I just need to email it to them. I can do it tomorrow.
Okay.
When I get back to the office.
Okay, well, let's give you the close of business on Monday or something, just in case something happens, okay?
And Judge, I thought we continued all my cases till March because I'm at the county attorney's conference. I apologize.
Well, there wasn't any note, I didn't find any notice here where they sent a notice. They thought that we previously set this for a status conference. And they might be right. It just didn't make it on the docket sheet. So it's not their fault and it's not your fault, but we've reached the conclusion we need with you getting the discovery, okay?
Okay, I appreciate it.
Wait just a second. Yes, go ahead.
Your Honor, this is Phil Dyson again. The other question that I had is, which I asked at the prior hearing, which you said you would discuss at this hearing, was setting a trial date.
Well, I'm not going to set a trial date until you get the discovery. And then we have a procedure to say whether any other depositions are needed or that sort of thing. If you can't agree upon that, then I'll schedule something. But I don't set trial dates until discovery is finished and depositions are finished on both sides. And if one side or the other is tarrying on that after you get this discovery, then I'll intervene. But so it's not hard to get a trial date here because of that. I don't have a lot of dates tied up because I don't schedule unless they're gonna go, okay? Okay, thank
you,
y'all.
Your Honor.
Thank y'all very much. Sorry to bother you, Wes. Thank you. Bye. Bye. Okay, does anybody else have anything in front of the court? Y'all have anything?
Judge, I've got a Carrington Mortgage Services versus Bartley motion for leave to file an amended complaint.
Go ahead and submit an order on that, okay?
We'll do that, Judge. Thank you. Appreciate it.
Okay, no problem. Does anybody else have anything? Okay. Okay, let's go off the record and we'll decide deeds and things. Is there anything else that needs to go off here?